You were not supposed to be driving, and yet you did it anyway. And you drove without ignition interlock. And again, we go back to the fact, I don't take it as true, but you're charged with intoxication manslaughter. It's calling 2021 CR 2127, State of Texas versus Hannah Marie Smith. I have parties announced for the record for the state.
Brian Brewer for the state of Texas.
For the defense.
Monica Guerrero for Ms. Smith.
All right, defense has filed a motion asking that the defendant's bond be reinstated. State, are you ready to proceed?
Yes, Judge.
Right from the start, this case hits hard: intoxication manslaughter. That's one of the most serious charges involving a vehicle. And here's the twist: she wasn't even supposed to be driving. So now the question is, was this just a mistake or a complete disregard for the court's orders?
Just so we're clear, some things happened. I think I remember this. Ms. Smith was not supposed to be driving. Ms. Smith, I believe, was behaving inappropriately and was asked to come to court. The court had no idea that Ms. Smith had been driving for who knows how long. And Ms. Smith drove to court, but she was in a vehicle on Zoom, and then she drove to court. So that's where we are. So Ms. Herrera.
And on that day that she came to court, apparently her retained attorney withdrew, and then I was appointed to represent her.
Yes.
So I haven't had this case very long. However, the court remanded her without bond on that day, and she's been in custody since. Her family is extremely supportive. They sold her vehicle so she wouldn't have a car anymore. Her employers contacted me, her boyfriends contacted me, civic leaders have contacted me, her mother has contacted me. They all want her to get back out so that she can go back to work and show the court what she's done. She's been in 12-step programs. She has not had any positive UAs. She tells me that, she's been doing everything that the court has asked her to do, and that she was unaware that Ms. Corley had filed an affidavit of non-driving. She had been blowing into an in-home device, and she would like very much to be placed with a bond so that her family can make her bond. That if she has a vehicle, that she will put ignition interlock in there. But as of right now, her mother has told me they have sold the vehicle and they no longer have anything for her to drive. Her bond was set at $50,000 in inception.
Well, even though Ms. Corley did an affidavit of non-driving, people in this court who are on DWI, I always let them know and have them present when someone is doing an affidavit of non-driving, because I tell everyone that they need ignition interlock, and they say, oh, they're not driving. And I say, well, they need to provide an affidavit of non-driving. My concern is she filed an affidavit of non-driving. Obviously, her signature is on it because it's an affidavit of non-driving, and yet she drove to court and she didn't have ignition interlock.
Judge, if I may, obviously, Judge, I was going to bring up my recollection of that day was the same as yours. I did want you to take judicial notice because I know you were on the Zoom that day. If there is an affidavit of non-driving on file, I presume that she signed it and that, she was aware that she wasn't supposed to be driving. Regarding the indictment in this case, it's a very serious charge, among the most serious charges you can get involving a vehicle. And that's why we believe it's important, Judge, to not take it lightly, the fact that she said she wasn't driving and then she was for sure driving that day that we see her on Zoom driving. We can presume that she was driving on other days if she thought she was just free to drive. The state would ask for her bond, if you grant her a bond, for it to be doubled to $100,000 along with full GPS house arrest.
Wait, this is a major red flag. She signed an affidavit promising not to drive and still showed up driving without an ignition interlock? In legal terms, that destroys credibility. And in court, once your credibility is gone, everything else you say starts to sound questionable. Would you trust this explanation?
I'm still trying to figure out, why should I grant her a bond when and mind you, Ms. Smith, I don't take any of the facts of these cases true because I haven't heard any facts. But what I have is you're charged with intoxication manslaughter. You did an affidavit saying that you would not be driving, and yet you were driving, which means you were driving without an ignition interlock, and you're charged with intoxication manslaughter. The number one rule when you have any intoxication offense, if you're doing an affidavit of non-driving, you don't drive. If you're driving, you have to have ignition interlock. So I'm not going to reinstate the bond. You're remanded without bond.
I'm sorry, I forgot that I had signed the paper and wasn't driving for that long. I'm really, really sorry. I have been doing so good and I want to continue to do good.
But you were driving without ignition interlock. But if you want to give testimony, I will swear you in. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Hannah Marie Smith.
All right, Ms. Burrell, do you want to do question and answer, or you just want her to state?
I just want her to talk.
All right.
I did not, I was not aware. I do remember signing the paper, but I was not aware that I was not supposed to be driving at all. I did tell court, Miss Linda Corley, I called and I had spoke to Roland. And I had told Roland, he didn't tell me anything about getting the interlock or calling pre-trial. There's something about I was supposed to have called pre-trial. I was never told any of that. I would have done it. I have done everything that I have been told to do. I would have done it. I'm in IOP, I'm in precision recovery. I went to an inpatient program. I have a sponsor. I work a 12-step program. I go to AA meetings. I go to see Rick Green regularly Tuesday and Thursday night. I fully participate. I'm on back on my mental health medication. Being in the IOP program has put me, I have found out that I have hyperthyroid and Graves' disease, which I wasn't aware of until I had gone into the IOP program. Mentally, physically, everything about me has gotten so much better. This past year to year and a half, I'm really sorry. The car is gone. You can take my license. You can revoke my license. You can do whatever. I'm not gonna drive anymore. I take the bus. I'm trying. I tried really hard for a whole year. I'm sorry.
State, any questions?
Nothing specific, Judge. I would just like the court to be aware, or just obviously, Judge. I mean, I think it's concerning that she's signing things, and the biggest concern we have whenever someone commits a crime with their vehicle is they're going to do it again, and she's not even aware of conditions that are part of her probation, or I'm sorry, part of her pretrial.
All right, and the court notes that there is a previous pretrial violation, Ms. Terrell, for hijack reading, but at that time, the court did not issue a judge's warrant or remand her without bond. But you knew you were not supposed to be driving, and yet you did it anyway. And you drove without ignition interlock. And again, we go back to the fact, I don't take it as true, but you're charged with intoxication manslaughter. So the motion to reinstate the bond has been denied.
Will the court consider any bond?
Not at this time. If you want to speak with the state and see if the state would be in agreement for a bond, but at this time, no.
And there it is, the judge shuts it down. Bond denied. Why? Because this isn't just about breaking a rule, it's about trust and public safety. When someone charged with such a serious offense ignores clear conditions, the court has very little reason to give them another chance. Tough, but predictable.
Ms. Ferguson,
Sit down.
this is, the setting date on this is May 16th. Ms.
Correct, it's
Loretta.
next week.
Okay. Court is calling 2021 CR 8724, State of Texas versus Tavon Washington. Can I have parties announced for the record?
Ryan Gerber for the state of Texas.
Kathy Compton for Mr.
And
Washington.
are you Tavon Washington?
Yes, ma'am.
All right, defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Washington, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
All right, it appears that the state is proceeding on the indictment as presented. Is that correct, Ms.
That's
Compton?
my understanding, yes.
Yeah, that's a phone. And that's where we look, and the person whose phone is ringing, you look around. Or is it the exit sign, because it's flashing? Deputy Laura, is there is not. Okay, I'm being told that is not an emergency. Oh, where's the influencer going? Mr. Stevenson?
Your Honor.
Your client has left the building.
Just try to bring it back.
All right, thank you, Mr. Stevenson. Okay. Mr. Washington, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Do you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Absolutely, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Washington, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There's a $500 fine, affirmative finding of deadly weapon, and no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Or sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea.
Yes, Judge. David offered State's Exhibit number 1.
Any objections?
No objection.
Mr. Washington, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulations, testimony, and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty. Are we proceeding with sentencing?
We're asking to do that, Your Honor.
Anything you wish to say on behalf of your client?
I would just ask the court to follow the plea bargain agreement.
Okay, what happened?
Probably about the worst day of his life. I think it was just a lot of things that with Tavon that kind of just came to a terrible head that day. And he's very remorseful. He wants to just move on and put this behind him. He's never been in any serious trouble before now, although the conduct itself obviously was very, very serious. He has spent enough time now in jail to where I believe that he just wants to be able to move on and live his better life. And I don't think you will ever see him here again. I think that he will be finished with this and move on to be a very productive person in society. He's a very intelligent young man. I think that he just made some really poor decisions that day. And unfortunately, it's one of those things where there have to be consequences. We understand that, but I do think that that's why the state offered the minimum sentence in this case.
And how much time does he have in custody?
How much time?
11 months.
Yeah. So he's well on his way to finishing it up, Judge.
All right, then I'll sentence you to 2 years in the prison. There's an affirmative finding of damaged weapon. Give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Washington, good luck to you.
Thank you.
All right,
Have a blessed day.
all right, you too. All right, who are the parties on Hannah Smith?
I'm present, Judge.
All right, if you will approach, please. All right.